We begin with some breaking news that's coming in. The Supreme Court has agreed to examine the validity of Places of Worship Act and has sought centre's response in 2 weeks. Now, this act is at the center of the Kashi and Mathura dispute. So important there that Supreme Court agreeing now to examine the validity of Places of Worship Act. Let's go across to Harish, who's joining us for more on this. Harish, this is an important move coming from the Supreme Court.
Yes, that's right. A very important development as far as the Places of Worship Act 1991 is concerned. Supreme Court today has issued notice, has sought a response of the government on, in fact, all nine petitions. That includes petitions filed by Subramania Swamy, Advocate Vishnu Jain, who is leading the charge for Hindu side in the Mathura and Kashi cases, and also Ashwini Upadhyay. And remember, this particular act provides for maintaining status quo on religious places as on 15th August 1947. The petitioners argue that this act by the parliament has taken away the right of Hindus to reclaim their religious places, and very significantly says that illegal acts of an invader cannot be legalized by this particular act. The petitioners also argue that the Hindus should be allowed to reclaim their religious places through judicial process, and no force can bar them from that. So these are the very significant arguments, and countering the argument of the Muslim side that the Ayodhya judgment had in fact validated the Places of Worship Act. The petitions counter that in fact the Ayodhya judgment might have said that this act is a legislative instrument to protect the secular polity, and it's a part of the basic structure of the constitution. But the Ayodhya judgment had not gone into the constitutionality of this particular act, and it's this act was never in challenge before the Supreme Court in Ayodhya case, and these were just obiter dicta, that is observations which does not have the force of a law. So these are the very important arguments put forward by the petitioners, and at the same time, this very act is at the central of the Mathura and Kashi dispute, we should remember. And in fact in Mathura, in Varanasi matter, where the judgment on the maintainability of the petition filed by 5 women Hindu petitioners is set to come on September 12. The Hindu side had in fact argued that the Varanasi matter comes under the exemptions in the Places of Worship Act, because the Varanasi Ganvapi complex comes under the Ancient Monuments and Archaeological Sites Act, and also that matter pertains to does not pertain to changing of religious structure. So why this is important is because Muslim sides had also filed intervention petitions saying that they should be heard before even the Supreme Court issues notice in this matter. Even notice should not be issued because it will instill fear in the minds of the Muslims who are already troubled after the Babri demolition and also after the Supreme Court judgment in the Ayodhya case. They also say that such petitions will in fact open floodgates for litigation against thousands of other mosques in the country. So these were the argument put forth by the Muslim side. So as of now, the Supreme Court has fixed the next date of hearing as October 11. By that time, the centre has to file its reply. So the Supreme Court's direction to centre to file a reply and issuing notice is very, very significant as far as the controversy over the Places of Worship Act 1991 is concerned. Back to you.